If you own a gun in America, what you thought you knew about your rights just changed on November 15th. And not in a small way. A major federal court ruling has come down and it's rewriting how gun laws are applied across the country. These are not tweaks, not minor clarifications, and definitely not optional details you can ignore. 8 core gun laws have been hit with changes that will directly affect how you buy, carry, transport, and even store your firearms. And whether you stay on the right side of the law from this moment forward. Here's the truth. Some of these changes give you more protection than you've ever had before, but others could put you in unexpected legal danger if you don't understand how they work starting today. The ruling came fast, the reactions are intense, and most gun owners have no idea that the ground beneath them just shifted. But you do. And by the time you finish this video, you'll understand exactly what this ruling changed and how to use it to protect yourself. Because these aren't slow policy updates buried in legislature. This is a federal court resetting the rules overnight. And the biggest mistake any gun owner can make right now is assuming everything stayed the same. It didn't. 8 major changes now define what you can and cannot do. And if you don't know them, you can accidentally step into a legal trap without even realizing it. Stay with me, because we're going through each change one by one. And trust me, number 1 is the one the government hoped you'd never pay attention to. Rule 8 is the first major shift, and it affects something almost every gun owner deals with regularly: buying ammunition. For years, different states have layered their own restrictions on top of federal rules, creating a messy, confusing system where something as basic as purchasing a box of rounds became a legal obstacle course. This new November 15th ruling cuts through that confusion. The judges made it clear that ammunition cannot be treated like a suspicious substance, and states can't build barriers that make lawful purchases difficult or intimidating. What this means in plain terms is simple. States that used to require background checks for ammo can no longer do so. States that blocked online sales or forced retailers to collect unnecessary personal data are now prohibited from enforcing those policies. And for the states that tried to impose purchase limits or tracking requirements, those rules are officially invalid. Buying ammo is now treated like purchasing any other legal product. No extra screenings, no delays, no intrusive monitoring. The process becomes uniform nationwide, restoring the straightforward right that most gun owners assumed they always had. Rule 7 brings another major correction, this time aimed at something gun shop owners, small dealers, and home-based FFL holders have complained about for years: unpredictable enforcement. The ATF's long history of vague guidelines, paperwork traps, and sudden license threats has made operating a gun business feel like walking through a minefield. But this ruling changes the enforcement landscape entirely. Gun businesses must now be treated the same as any other lawful industry. That means no more revoking licenses over small clerical mistakes, no more nitpicking audits designed to shut people down, and no more endless delays in approving new applications. The court has set a strict standard. A license can only be denied or revoked if there is actual evidence of intentional criminal wrongdoing. And for those applying for a federal firearms license, the government is now required to process the application within 60 days, something that used to drag on for 6 months or more. For home-based dealers who faced harassment from local officials, this ruling gives them federal backing. The message is clear: if you're following the law, the government can't treat you like a criminal. Rule 6 targets something far more hidden, but just as troubling: digital surveillance. Over the past decade, agencies have quietly tracked gun owners' activities through credit card data, location histories, online searches, and even social media habits. None of it was publicly acknowledged, and most gun owners had no idea their lawful behavior was being monitored. The November 15th ruling shuts that down. The court declared that exercising a constitutional right cannot be grounds for data collection or digital tracking without a warrant or criminal suspicion. That means your online ammo purchases, the times you visit a gun store, your searches about firearm laws, or the firearm discussions you post or read on social media are all protected.
Agencies can no longer use algorithms or data scraping to build profiles on lawful gun owners. And if they attempt to access digital information without cause, You are under no obligation to cooperate. You can simply assert your rights. Digital surveillance of lawful gun activity is prohibited, and you do not consent to searches of your devices or records. This ruling restores a level of privacy that should have never been compromised. Rule 5 takes direct aim at states that have made carrying a firearm intentionally difficult. For years, many states imposed long delays, subjective good cause requirements, or high fees that priced ordinary citizens out of exercising their rights. That era is now over. Under the new standard, every state must process carry permit applications within 30 days. After that, if the state has not taken action, the permit is automatically approved. This ruling removes the power of states to stall, obstruct, or financially burden lawful applicants. Good cause requirements are abolished nationwide, meaning you no longer have to justify why you want to carry. And the court capped permit fees at a maximum of $50, eliminating the ability of certain states to use money as a form of discrimination. The court's message is firm. A constitutional right cannot be turned into a privilege controlled by bureaucratic delay or subjective judgment. If you are eligible to carry, the state must respect that without unnecessary hurdles. Rule 4 addresses an issue that has worried gun owners for decades: centralized registries. For years, pieces of data collected through background checks or state systems were quietly being digitized, stored, and sometimes shared with federal agencies. This ruling declares that kind of record-keeping illegal. The federal government must wipe every digitized gun record within 90 days, and states that share information with federal agencies must stop immediately. The ruling is clear. Searchable databases of gun owners violate federal law, and the ATF is prohibited from maintaining them. The court is taking this seriously. Agencies must prove records are destroyed. If they fail, they risk contempt charges. This ruling effectively blocks any attempt to build a national registry through indirect or digital means.
It restores the fundamental protection that gun ownership information is private and cannot be stored, tracked, or cataloged. Rule 3 tackles one of the most controversial issues in recent years: gun confiscation without criminal charges. Red flag laws and civil asset forfeiture have been used to seize firearms based on accusations, suspicions, or the possibility of future danger without the gun owner being charged with a crime. The new ruling shuts that door completely. Law enforcement can no longer take your firearms during an investigation unless you are formally arrested and charged. No seizure without arrest, no seizure without charges, no seizure without due process. This stops the practice of authorities saying, "We'll hold on to your guns while we look into this," or "Someone reported you, so we're taking them." From this point forward, your firearms can only be taken through proper criminal procedure, not civil claims or speculative concerns. The court is reinforcing that constitutional rights cannot be suspended based on assumptions or accusations. Rule 2 transforms how police officers interact with gun owners. For years, qualified immunity shielded officers from personal responsibility, even when they violated clearly established rights. That protection is now removed when it comes to Second Amendment violations. If an officer unlawfully seizes a firearm, arrests a lawful carrier, or restricts your rights without legal basis, they can be held personally liable, financially and criminally. Departments across the country are now rushing into retraining programs because the consequences are real. Multi-million-dollar personal judgments are already appearing. The court ruled that if a reasonable person would know the action is unconstitutional, the officer should too. Ignorance or "I didn't know the law" is not a defense. This means when your rights are violated, the responsibility doesn't get pushed off onto taxpayers or city departments. The officer who broke the law pays the price directly. Rule 1 is the most powerful change of all because it shifts the legal foundation of every gun case moving forward. The court has elevated the Second Amendment to the highest tier of constitutional protection. That means any law that touches your right to own or carry a firearm must pass strict scrutiny, the toughest legal standard in American law.